to grow your business in these challenging times. I'm Wynn Thurlow, Executive Director of MedTech, New York's association dedicated to growing the life sciences ecosphere. We connect the biomed industry through business development, education, and advocacy. For those of you who'd like to learn more about MedTech and how you can connect with our members, please check us out at medtech.org. These Thursday conversations are integral to what we do here at MedTech, and we're able to make this series free to you thanks to the generosity of our sponsors, Regeneron Pharmaceuticals, MPR Associates, Thermo Fisher Scientific, GKG, Barclay Damon, and FuseHub. We'd love to have your company or organization join us as a sponsor so that we can continue to deliver high-quality education to our diverse audience. You may also find a calendar of these discussions on our website, where you can also listen to past episodes. I'm pleased to welcome Linda Clark of Barclay Damon to this afternoon's conversation, where we'll tackle issues of liability, tackle issues of liability and immunity, two subjects of particularly increased interest in our current public health crisis. Linda is a partner at Barclay Damon's Albany office, where she serves as the firm's healthcare controversies team leader and a member of its COVID response team. A nationally recognized litigator with over 20 years of experience, Linda serves as lead litigation in the prosecution and defense of claims brought in state and federal courts on behalf of business and institutional clients. Linda is a trusted health advisor to the healthcare provider community, pharmaceutical companies, and pharmacies nationwide in resolving disputes and government investigations. She represents healthcare professionals and entities in administrative proceedings, hearings, and appeals before various federal and state regulatory agencies. We're thrilled to have her join us today on Propelling New York Forward. Welcome, Linda, and thanks.
Thanks, Wynn. Great to be here. I'm hoping for many of you that are joining us this afternoon that the only thing between you and a 4th of July vacation might be this presentation this afternoon. And what better way to kick off a 4th of July vacation, but then with a discussion of COVID and COVID liability. So when should I go ahead and pull up my presentation?
Go ahead.
Great.
As you're doing that, I will remind our audience that Linda and I will chat for a while along with her presentation, and then we'll open it up to some questions for those of you who may have them. You may find a chat and Q&A button at the bottom of your screen as you hover your cursor over the screen. Feel free to type in those questions to us, and we'll get to as many of them as we can. Thanks, Linda.
Great. So unlike many of you who are probably on this webinar, I'm actually, as you could probably see, at work today. And as we enter what is amazingly our 4th month dealing with COVID issues, it's about the right time to really be thinking about and talking about where the legal responsibility might lie for various types of entities. Today, I'm going to be talking a little bit about COVID liability, and more particularly health-related entities, and then more broadly, some other kinds of liability for other types of entities. When we look at the statistics, it's time to take stock and trying to figure out how big an issue this was. I think when I started researching and preparing this presentation a couple months ago, we were all hoping that this would be a short-lived kind of problem, and maybe this issue of COVID liability might not be as big a one as we thought. But looking today we have 2,600,000 cases nationwide and 128,000 deaths nationwide. In New York alone, we're pushing almost 400,000 cases. So if you sit back and you remember where we were in March, it's just unthinkable that we could be hitting these numbers. And unfortunately, looking at the national numbers, nobody can really say that the end is in sight. And so I think this issue of COVID-related liability and responsibility is going to be an increasingly important one in the months and maybe even the years to come. I mean, if you think about it, if New York were a country, in and of itself, it would be right up there, probably at this point, I haven't looked today, but in the top 10 of all the countries in the world in terms of the number of COVID cases. Now let's take a look at how big an issue this really is. It's hard to sometimes get perspective, but let's say we looked at another kind of legal case that you might have heard of. Anybody who is a night owl has probably seen on the TV the ads for asbestos cases. So if you look at the asbestos litigation that is nationwide and has been for decades, that is fueled by as few as 3,000 mesothelioma diagnoses every year. So imagine with a mass tort situation like asbestos, 3,000 cases, at least of mesothelioma a year, are propelling that massive litigation across the country that has taken down huge companies that you've probably heard of, Owens Corning, go on and on. Imagine now, as compared to that, the 128,000 deaths that have occurred in our country as a result of COVID just in the last few months. And let's stack on top of that COVID-related injuries. So it's it's absolutely horrific and tragic to be talking about deaths in those numbers. We don't know what those numbers will end up being. But let's add to it what scientists are now discovering are the COVID-related injuries that are being suffered by people who are actually surviving the illness, but having extreme long-term organ complications and other kinds of injuries. I think when you really take a look at that context, we can see that issues of COVID responsibility in our legal system are going to be with us for some time. So today, we're going to be talking about, we're going to take a relatively deep dive into what are some, fairly complex legal issues. I'll do my best to guide you through them. I think our audience is not just lawyers, but also a lot of other people that are involved in the medical system in one way or the other, in our healthcare system. So we're going to talk a little bit about the New York State immunity and its exceptions. As many of you may know, New York was one of the first states to pass a very broad immunity provision, which protects certain types of businesses and individuals from liability for COVID-related injuries and deaths. There's a lot of complicated exceptions to that. And then we have to compare the New York immunity and the other state immunities to some federal immunity declarations that have been issued. We'll talk a little bit about, more specifically, some of the healthcare facility issues. We all know, sadly, about the rash of cases and very sad deaths that have occurred in healthcare facilities such as nursing homes. And then we'll talk a little bit about some of the other states' immunity laws and how they may affect the equation. So let's take a look first at the New York immunity law. So in the normal course, if you had something like a COVID-related injury or any kind of injury, it would be dealt with in the context of our civil justice system in New York and beyond. And many of you are surely familiar with the basic concept of negligence. Well, there was an early determination made in New York, particularly by the governor, that in the context of COVID-19, in the really the fog that we were in, especially in March and April, regarding the nature of the disease, and remembering that in the heat of the battle, the number one priority was to get people treatment and to cut through red tape. It was in that environment that the governor issued the March 7th emergency declaration, which created very broad immunity for various types of providers and facilities. The immunity in New York we call 30D exists. It's retroactive to March 7th, which was the first day of the emergency declaration, and it's going to remain in effect in New York until the state of emergency declared by Governor Cuomo is lifted, No one knows exactly when that might be. So the New York immunity has very specific parameters for the immunity. It applies to a healthcare facility or a healthcare professional that is arranging for or providing healthcare services pursuant to a COVID-19 emergency rule or otherwise in accordance with applicable law. So when you take a look at that language, you can see that this is not a blanket immunity. It doesn't apply to all circumstances or to all types of providers or entities. It has to be a healthcare professional, okay? Doctors, other folks that are considered part of the healthcare professions under New York law. The person has to be arranging for or provided healthcare services, and those services have to be provided pursuant to the emergency rules or in accordance with the applicable law. And we're going to come back to that language and see how it might be important. The other component is that the act or omission has to occur in the course of arranging for or in providing healthcare services, and the treatment of the individual has to be impacted by the healthcare facilities or healthcare professionals' decisions or activities in response to or as a result of the outbreak, and in support of the state's directives. So you can see that with this language, the first paragraph and the second paragraph, it's a lot to wade through, even for lawyers that are deeply involved in trying to understand what the scope of this immunity is. Lastly, the healthcare services have to be provided in good faith. The idea here generally is to protect professionals and facilities that are in the thick of it, on the front lines of the COVID-19 pandemic, and give them some security that if they do the right thing, if they follow the rules, and they are brave, and they attempt to protect and care for people with COVID, that they won't be second-guessed after the fact. But there are limits and exceptions to the COVID immunity in New York. Those exceptions are based upon well-known concepts in the law. And if the treatment or activities fall into the category of willful or intentional criminal misconduct, or gross negligence or reckless misconduct, or if they involve an intentional infliction of harm, then there will be no immunity. So this is where the bar is set in New York for COVID liability and the application of these immunities. And the other caveat is that decisions resulting from a resource or staffing shortage won't fall into this exception. So the idea here is that there's exceptions to the exceptions, okay? But we recognize that there are serious staffing shortages and resource shortages. And the legislature and the governor didn't want the frontline providers being held responsible for the understandable staffing and resource shortages that could impact the care of COVID patients. So just pause again and take a look at those terms: willful, intentional misconduct, gross negligence, and reckless misconduct. We'll come back to those. Well, we need to remember too, what is the backdrop of liability in New York, especially for the nursing home scenario. We had in New York, before COVID came along, a very robust statute, a very robust nursing home statute called 2801D. It created very broad rights for nursing home residents who became injured as a result of a deprivation of rights. And that existed all before COVID. So one of the interesting issues is how the public health law, section 2801D protections for nursing home residents is going to interact with those COVID liability immunities. We have embedded in a lot of different areas of New York law the concepts of gross negligence and recklessness. Those are terms that lawyers hear very often in our scheme of tort law and legal responsibility. And so those are relatively well-defined terms in the law. But where they're not defined is in the facts. You have facts, and then you have the law, and outcomes depend upon how the law is applied to the facts. Well, COVID is such a novel scenario. The scale and scope of this pandemic is really unlike anything that we've seen in recent times. So the big question is, how are the courts going to apply this immunity using these traditional terms of gross negligence and recklessness to the extraordinary facts that are presented by the COVID crisis? Lastly, we're going to talk a little bit about how the immunity, also called EDTPA, interacts with the pre-existing statutes like 2801D. For example, the immunity statute says in its, by its very language, that it applies, quote, notwithstanding any law to the contrary. So one of the big questions is, will the immunities that we've been talking about, designed to protect facilities and professionals, will they supersede? Will they trump those pre-existing rights that patients may have? It's a little bit of an unknown. Also, how are courts going to interpret the terms willful, intentional misconduct, or gross negligence? Now, you have to remember, of course, that when you look at the COVID immunity statute, which has now become very controversial, at the time that the statute was passed by the legislature, we were in a place where the curve had not been flattened in New York. We were climbing the mountain that the governor often talks about. And the concern was about protecting providers. Well, a lot has happened since then. I'm sure that many of you have seen the media coverage of the terrible situation that we're seeing in nursing homes and other facilities. And there's been quite a backlash in the media, calling into question whether or not it was appropriate to provide facilities with that kind of broad, almost blanket immunity, when there seemed to be real questions about whether or not that was appropriate under the circumstances. So now we see, with the pendulum swinging the other way, now that the curve has flattened and we're over the mountain, there's a concern about the rights of the patients, and we're seeing some assembly people and politicians who are interested in rolling back those immunities. They argue that the gross negligence standard, which is a very high standard, is too high, and that the standard is so high that the immunity statute will prevent there from being any kind of accountability of executives and facilities for what has happened with nursing homes and other similarly situated facilities. Let's pause and talk for a minute about federal immunity declarations. We'll be going from the state law provisions to the federal law provisions. The state law immunity provisions are known as the PREP Act. The PREP Act declaration came out on January 31st, 2020, which is interesting, given the timing of all that has transpired. And the PREP Act immunizes a covered person from liability for claims for loss relating to the administration or use of a covered countermeasure. Okay, I apologize for the sirens in the background. I'm in downtown Albany, so that can happen. And if you take a look at the federal protection under the PREP Act, you can see that it's very different from the state law that we just talked about. The state law that we just reviewed is really designed to protect frontline responders and healthcare providers, whereas the PREP Act is really designed to insulate very specific types of entities and persons from a very particular type of liability. So let's take a look at the four elements that have to be met in order to have immunity under the federal PREP Act. First of all, the individual or entity must be a covered person. The legal claim that they're resisting has to be a loss. And that loss has to have a causal connection with the administration or use of covered countermeasures. The medical product that caused the loss must be a covered countermeasure. So you can see that under the federal statute, what they're really looking to do is to create a safe harbor for those that might be in the business of creating responses and products to counter the pandemic. What are covered persons? Well, the government is a covered person. Manufacturers and distributors of covered countermeasures are covered entities. Program planners, and qualified persons who prescribe, administer, or dispense the covered countermeasures, including licensed healthcare professionals. The PrEP Act provides immunity from liability for those covered persons when they're presented with a claim for death, physical, mental, or emotional injury, illness, disability, or condition, even fear of injury, which can be important in the COVID context where you have exposure, or loss or damages to property, including business interruption loss. And of course, one of the components of liability under the PrEP Act relates to that causal relationship. So it can't just be a coincidental relationship between the injury that was sustained and the activity that's protected. It needs to be a causal one. So the immunity applies to a claim for loss, damages, injury, whatever we're talking about, that has a causal relationship with the design, development, clinical testing, or investigation, manufacturing, label, distribution, it goes on, of a covered countermeasure. So the Federal PrEP Act is really designed to provide protection to those who are developing, manufacturing, prescribing, or administering countermeasures. And what is a countermeasure? That's a sort of an unusual term. Well, in the context of COVID, countermeasures include a pandemic or epidemic product. Okay, think testing, think drugs to combat the symptoms of COVID, and the statute says that a qualified product includes something that would diagnose, mitigate, prevent, treat, or cure a pandemic or epidemic that is FDA approved, has to be FDA approved, licensed, or authorized. So you're not going to get the PrEP Act coverage if you're not FDA approved, licensed, or authorized, and you don't get the protection if it's not designed to treat, mitigate, or cure COVID. The other class of countermeasures that is covered in the PrEP Act is a security countermeasure. Think cybersecurity. Lastly, it can cover a drug or biological product or device, could be of interest to some of the folks on this call, that the US FDA is authorized for emergency use. There's very narrow exceptions to the PrEP Act. Unlike some of the unusual language that we saw in New York related to gross negligence and recklessness and all those things, the exception under the PrEP Act exists where, one, the covered person intentionally acted to achieve a wrongful purpose, okay, you had bad intent, or you did so knowingly without legal or factual justification. Lastly, there is no immunity where there's a disregard of a known or obvious risk that's so great as to make it highly probable that the harm will outweigh the benefit. So you can see, even with the Federal PrEP Act, with the language that's used for these exceptions, depending on how all this plays out. We've also already seen some false starts with certain types of medications. We see some false starts with different types of testing devices. And it'll be very interesting to see how the courts apply these kinds of immunity provisions to different types of scenarios. It's also important to remember that because of this emergency situation, especially going back to March, April, probably less so in New York, fortunately in June, but maybe places like California and Texas, that the whole purpose of these waivers and these immunities was to cut through the red tape, to make sure that the resources, the precious healthcare resources that we have, get immediately to the people that need them and to the places that they need to be. And so in addition to the waivers and the immunities that we've been talking about, you should know, and many of you might be aware, there has been a massive jettisoning of all kinds of regulatory requirements that apply to the healthcare system. The vast array of intricate licensing provisions and standards that traditionally have applied to hospitals and laboratories, nursing homes, and you name it, hospitals, have been suspended during the COVID pandemic. Here's an example of some of the, really, from a healthcare law perspective, just the breathtaking and extraordinary and unprecedented waivers of traditional regulation of healthcare professionals and healthcare facilities and products. This is just a few examples. Let's pause and talk for a minute about the situation that we have at the federal level and certainly at the state level with some of the problems that have arisen as a result of the COVID crisis and treatment, particularly of patients in facilities such as nursing homes. In addition to the difficulties that nursing homes have had in managing the pandemic, we have also seen some major problems, some really heartbreaking problems with communication. So we had situations in New York and elsewhere where there was great difficulty, partly because of the lockdown of a lot of these facilities. I don't know about the folks on this call, but I know many of us have grandparents. I have an in-law that I haven't seen since St. Patrick's Day because of these lockdowns, except through a window. It's a really, really difficult time for them and their families, difficult time for those frontline providers that are taking care of those people. But one of the consequences of all of that has been a real breakdown in communication. And in New York, there have been newly enacted provisions to ensure appropriate communication and notification to family members whenever there is a situation where someone has tested positive for COVID, or if there's been a COVID-related death. So for example, Executive Order 202.18 requires nursing and adult care homes to report COVID-19 cases to the family members and the next of kin within 24 hours. Then on April 17th, there was an additional requirement providing for penalties for facilities' failure to follow those notification requirements. On the federal side, the federal government has issued notification requirements applicable to nursing homes. And among other things, nursing homes are now required to inform residents and their representatives and their families of those residing in the facilities who are confirmed or suspected to have COVID. With respect to nursing homes, we're starting to see some momentum build toward more scrutiny, more investigations of nursing homes to determine where legal responsibility might lie for many of the nursing home deaths. This has been fueled by some very well-known incidents in our region, including the Department of Justice investigation of the National Nursing Home Initiative, which is a national approach to this issue. On April 10th, they announced the investigation of the Soldiers' Home investigation, that scenario. And even later, on April 23rd, we're now seeing a joint investigation of nursing homes that is under full way by DOH and the Attorney General's office. We're seeing that on the federal level as too, with CMS tightening up their surveys and review of nursing home incidents. On May 5th, now that these surveys are being completed, we're getting a lot of reporting, a lot of information about violations in DOH-operated or regulated nursing homes. A lot of this controversy about nursing homes and reporting really goes back to what I think about as hindsight being 2020. If you go back to April 22nd, you might remember some of the governor's addresses where the message there was nursing home patients have to be able to go back to nursing homes, And there were quite a few restrictions on limitations that could be placed on the return of a patient from a hospital with COVID to a nursing home. But let's look at the date, April 22nd. You might remember at that point, there was a concern about a surge that could potentially be overwhelming the capacity of hospitals and the ICU facilities. You know, we had the care ship, we had the Javits Center, we had the Army Corps of Engineers coming in preparing for that tidal wave of cases. Fortunately, we know now on July 2nd that we didn't end up needing all of those beds thanks to the great behavior, frankly, of New Yorkers coming together and pushing back and curbing the tide of COVID cases. But on April 22nd, that was definitely the message from the governor and from the Department of Health. You have to take nursing home patients back. There's been an outrage nationally about the conditions and the standards that have applied to some of the major nursing home chains. Some of us in the healthcare field, in the healthcare litigation field, have some concern, though, that a lot of these headlines and these media-driven campaigns may not be driven by the facts. We're starting to see just the front edge of nursing home related liability cases. So I pulled some headlines from some publications where we're starting to see ads, we're starting to see the front edge of what we think could be quite a wave of nursing home liability cases. Let's look at the statistics. As of June 22nd, there have been 6,250 confirmed deaths in New York State alone in nursing homes from COVID. And the June 2nd survey that was published by CMS reveals that 26,000 residents of nursing homes nationally have passed away. That's an enormous number. And let's look at the chronology here. This is going to be very important in the cases that will arise out of this crisis, and particularly the nursing home situation. It's all going to be about who knew what when and who acted reasonably and who didn't. So let's look at May 10th on the calendar here. Governor Cuomo issued Executive Order 202.30, finally reversing the state's nursing home admission and readmission policy. And so there was essentially a 180 when there was this realization developing that, number one, we probably wouldn't need all of those ICU beds, and that the risk of returning nursing home patients to the nursing homes might outweigh the benefit of protecting and preserving those additional ICU beds, since it didn't look like we would need them. The details of the new standard are shown here. The new standard prohibits hospitals from discharging any patient to a nursing home unless the operator or administrator first certifies it's able to properly care for the patient. Let's remember, not all facilities have the ability or the facilities to segregate COVID and non-COVID patients. The nursing home and adult care facilities are now testing all personnel twice a week. And I can tell you anecdotally that we're having clients report that there are a lot more positive tests in these facilities than expected. But for some reason, there are some idiosyncrasies at work, and there are not positive cases in patients everywhere where there are positive tests for workers. So the thinking is that PPP must be working.
Linda,
yes.
Linda, this is Wynn. Can I interrupt you for 1 second while we're on this topic, because we've gotten a question that's come in that's relevant to this particular issue, and one of our viewers asks, is there, if a resident in a nursing home becomes infected as a result of a contact with a staff person, is both the employee and the facility potentially liable? And what protections does a facility have given the requirement now that it tests its personnel twice a week? Does that offer some sort of protection? Where do you think we're going in terms of individual and corporate liability for residents of nursing homes and adult care facilities who contract as a result of employee contact?
Sure. Well, the reality is that individuals always have responsibility, just like doctors, for example. Doctors can have exposure to malpractice cases, and their facilities can have exposure to malpractice cases. The reality is, because of deep pockets and that kind of thing, that the liability is usually directed more toward the facility. And there may be insurance coverage for both the individual, depending on what kind of professional you're talking about, nurse, licensed professional, as opposed to a direct care worker in a different kind of facility. But this really goes back to some of those general concepts that we talked about: gross negligence, recklessness. I've been reading with interest some of the blogs and some of the articles that are being put out from the plaintiffs' bar, the lawyers that would be taking these cases. They're taking the position that those immunity provisions that we kind of sliced and diced earlier don't apply when a healthcare professional or facility deviate from the requirements. Okay, so if the standard of practice is testing 2 days a week, right? I believe that the plaintiffs, who are on the other side of the fence from me, are certainly going to take the position that that kind of conscious disregard of a very clear standard is tantamount to gross negligence or recklessness, and that there would be no immunity at all. From my perspective, when you have these situations with staffing shortages, let's remember, we're hearing from home health care providers, from nursing homes, all kinds of facilities, that the rate of call-outs with workers is extraordinary, because all you have to do is get traced, right, to some event, activity, or to someone who's tested positive, and boom, you're quarantined. Not to mention the high incidence of illness within the healthcare worker community, especially outside of hospitals where there's really good PPE. So these staffing shortages, you might remember that the New York Community Statute has an exception to the exception for injuries caused by shortages, right? Shortages of PPE, shortages of staff. So this is going to be quite a melee. Does the exception apply? Does the exception to the exception apply? And this is a good time to raise an interesting issue. Those are a really great question, by the way, I have to say. So who's going to decide what's a gross negligence and what's reckless, right? Is disregard to let's take that example that you just gave of the 2 tests a week rule. Is that gross negligence? Is that recklessness? Well, the reality is that under New York State's laws and almost all states, sometimes judges don't get to decide that. The way that the legal system works is that the judges get to decide. They'll look at the lawsuit, right, up front, and the judge is going to decide, is there a question of fact here? The judge doesn't get to decide the facts. The judge gets to decide the law. And as long as the facts state credibly that this activity amounts to gross negligence, okay, under our legal system, it may be difficult to get that kind of case dismissed up front. It's the kind of case where if it depends upon the facts, then it has to go to a jury. Under our Constitution in New York, a jury gets to generally decide what the facts are. And the facts, the devil's going to be in these details. Was there a frank disregard of the 2-week test rule, or did the employee just not show up for the test? What are the facts? Is that attributable to the facility, or is it just the individual? Was there a policy in effect that called for the testing? Was there not enough tests available? What are you going to do? Leave people not cared for when there aren't tests available? We hear that, especially in the preceding weeks, that's a problem too. So ultimately, are these cases going to be dismissed up front based upon the immunity provisions that we've talked about, with terms like what is gross negligence? What is reckless conduct? we'll have to see. Well, we're hoping that judges will really, apply these standards vigorously and weed out cases that were meant to be dismissed under the statute and take a very rigorous look at garden variety allegations. So hopefully, does that answer your question?
I think so. I'm sure we'll hear from our audience if it doesn't. But thank you. I'll let you
Right.
keep going.
But actually, I'm glad you interrupted me because we're talking about these things in the abstract, but taking a moment and talking about these actual situations, right, is really the lawyers who nobody knows exactly how this is going to play out. Okay. So now, continuing on our trajectory here. You can see some of the headlines from the Wall Street Journal and other major publications, very, very critical of that decision to allow or require nursing home patients to go back to nursing homes. But you can imagine these basic legal principles playing out in a lot of different circumstances. If employers need to test and they don't outside of the healthcare system, right? What is the liability going to be there? Any of you who are finally in upstate New York, we're in some of the advanced phases of reopening, but I'm going to get a haircut, for example, for the first time in 3 months, and getting my temperature taken. And I'm seeing a lot of differentiation. Some, and I'm watching it with interest, obviously, but some people are keeping a log, and I'm signing a waiver, right, when I go someplace. Others are not. Some are giving me a mask, some are, not necessarily. So these principles that we're seeing playing out in a more advanced way in the healthcare system are also going to play out in other scenarios that we're already seeing. We saw, for example, this week, I mentioned in the governor's address, the 75 workers in the Montgomery County aluminum fabricating plant who have tested positive. That's a large number. There's more tests coming back out of 500 workers. That's a huge problem. Those people, think about this. Those people go home, right, and they may infect their parents, grandparents, or community members, right? Now, Wayne, one question you asked me to address when we spoke was, how does that work for employers, right? Well, in New York, generally, employees can't sue their employers. Okay? There's a very high standard for that. Has to be, very, very reckless, very, very high level of bad intentional or, reckless conduct before you can sue your employer because you have workers' compensation. And workers' compensation is your only remedy in New York. But third parties are not barred from suing your employer. So I don't want to get too far off it, but this is just as important as anything else we're talking about. But in the asbestos cases, we have something called take-home exposure. So in the asbestos cases, for example, in all exposure cases, doesn't matter what we're talking about, there can be a liability of a manufacturer, right? If an employee comes to work, becomes exposed, let's say, to asbestos dust, and then goes home, and a third party, a wife or a child, may shake out the clothes and do the laundry. That is well established in New York and nationally, those take-home exposure cases. I'm anxious and interested to find out how these take-home exposure concepts are going to play out in a COVID scenario. So even though an employee might not be able to sue an employer, if that employee takes home the coronavirus from a place with a big outbreak, perhaps because of bad practices, to people at home that are affected or injured have a claim against the employer. Those are some of the things that we're waiting to see in the legal system. Okay, so just kind of again carrying some of these concepts that we've been talking about abstractly into the reality of now. We have this big push now to look at the nursing home situation, but I think we're going to see this in other scenarios as well. We have the federal government really trying to get their arms around what the best practices should be for infection control at facilities. And now we have an effort by some of the legislators to roll back the immunities for certain types of providers. The pendulum has now swung. You might have heard too on the federal level, as part of the COVID funding legislation, that at the very highest level, many employers and manufacturers are pushing for immunity more generally outside of the healthcare context. This isn't just a problem with nursing homes. This is a crisis in all kinds of healthcare facilities where you have that kind of density. But it's really a challenge for providers that are dealing with the developmentally disabled, because you want to respect someone's right to independence, and it's a real challenge sometimes for healthcare providers, the people that take care of the developmentally disabled, to manage behavior and tell people, they can't go to their job, or they can't be in this room, or they can't interact with co-residents. And so we're starting to see some media attention and some investigations of other types of facilities. So we're starting to see the tip of litigation. I mentioned some of the cases that are being brought for injuries, for frank injuries and deaths. We're also seeing litigation now on behalf of the healthcare providers. So we have a case brought by the New York State Nurses Association, filing 3 lawsuits challenging the state and hospitals with respect to the conditions that they have to face at work. There was one today, actually, that was brought by the NYPD, I believe, by the union, challenging the conditions that they're working in. We're seeing healthcare providers at facilities raising the question of whether or not it's appropriate to have them working in scenarios that could be risky. And New York might have been on the forefront of a lot of these issues in terms of immunity, but since then many other states have passed very broad immunity laws. We're not going to get into every one, but they're all slightly different. 14 states have similar immunity laws protecting nursing homes and other long-term care facilities from liability. Here's a few of them. It does change quite rapidly. And of course, it's creating an awareness across the country about the need to protect people in those types of facilities, and a lot of controversy over the breadth of these immunity provisions. So healthcare providers, but really everyone now that we see these principles playing out even outside of the healthcare field, really need to be very focused on documenting what they did or didn't do, what they knew or didn't know, in order to protect themselves from this type of liability. In fact, there's even some concern that healthcare providers could be accused of filing false claims for Medicaid or Medicare residents if the care provided is somehow substandard. Okay, well, that's the end of my formal presentation. We've got a few minutes for questions, Wynn. I encourage everyone to shoot Wynn a question if there's something you'd like to talk about.
Yeah, Linda, thanks. Let me start with one of the questions that has come through, and that is, as you've talked about the various immunity provisions that have been adopted, at the same time, you've also talked about efforts or some desire on the part of some folks to roll back some of those immunities. What level of protection do companies, do folks have if they're operating under an immunity? Can we assume that immunity will continue regardless of the change in the law, or are we facing a shifting standard that we have to worry about?
Right, so there you get into questions of retroactivity, right? I think that's what you're asking about. Mm-hmm. And generally speaking, the law frowns upon retroactive application of new legal concepts. If it's a law that really is just codifying an existing concept, that's one thing. But I would be surprised if these immunity provisions could be rolled back retroactively. And I think that I think the facilities would have a very good argument that that would be unconstitutional and improper.
And can we also talk, Linda, a little bit about workers' compensation? Another question came in and said, is it possible that an employee may file a workers' comp claim for a COVID-related injury and be awarded a temporary disability status?
So now you're into the esoteric world of workers' compensation, and there are standards that define under that set of laws when you've incurred a disability. It's very, very complex. I do not know, especially with the emerging issue of COVID injuries versus COVID deaths. Obviously, death is, if you got that from your workplace, the causation issues are going to be very interesting there. If you, let's say you have a worker that works in a facility where they're exposed to COVID, but they also went to a rally the night before. How do you ultimately prove that you got the COVID infection from your work, where you might have PPP and all the other things you do in your life where you may not? These causation issues are going to be very, very challenging, not just in the disability workers' compensation world, but also in the civil liability world. I think, in the nursing home context, where people are in a static environment, it's a little bit easier. But I think more generally, it's going to be very interesting to see how judges, even in the workers' compensation and disability world, determine what the standard is for a COVID-related injury. And remember, the injuries that are resulting are sometimes related to pre-existing conditions. So someone might have an exacerbated asthma condition or a lung injury that they might have had partially before. I think it's far from certain exactly how those issues will play out. But again, great question.
And we have time, Linda, for one last question, and that is, what can folks who operate non-healthcare facilities, what should they be doing, and what kind of protections exist for visitors to office settings or other non-healthcare related facilities?
Very, very good question. So when I came to work today in a non-healthcare setting, I had to fill out an online questionnaire, right, indicating that I hadn't been to any of the quarantine states, that I don't have a fever, that I'll abide by the rules, all of that. I think those are best practices, typically governed by your reopening plan, right, as an employer. Everybody has to follow that quite carefully. I think there's liability if you don't. So I think that most places are being very careful about that. And those are the kinds of things that you can do and document. Documentation is going to be king, and I think after the fact here. But there's another interesting question especially with visitors, right, non-employees, about waivers, right? So if you had gone to the Trump rally, on your way in, you would have been required to execute a waiver of liability, saying you're aware that by going into a dense environment, that you could be exposed and you're not going to hold them accountable. Matter of fact, today, one of the interesting headlines in the news was that the NFL is going to require attendees to sports events to sign a waiver, saying you recognize that it's risky and you could get COVID and you're not going to hold them responsible. The problem is that generally the courts have not been very vigorous in upholding general liability waivers. So if you go to an ice skating rink and on the back of your ticket, it says that you understand ice skating's risky and you promise not to sue them if you fall and hurt yourself. Generally speaking, those waivers have not been all that effective in a litigation context. And I think we will see that same debate in the COVID context. But I think they might have a little bit more teeth if they're specific.
Great. Well, Linda, on that note, we're going to have to wrap up today. I want to thank you again and let people know you can see on the screen Linda's contact information. Barclay Damon has been a terrific partner for us at MedTech and for our members, where they deliver high quality legal services to our members. We would encourage you to reach out to really any member of the Barclay Damon team. Also want to remind folks that next week at this time, we'll welcome Randy Walken, the CEO of MACNY, the Manufacturers Association, where we'll discuss how companies across upstate New York are preparing for future challenges, both those expected and unexpected. Again, on behalf of the MedTech Association and all of us on the Propelling New York Forward discussion team, want to thank you for your participation, and we look forward to seeing you again.
Welcome. And when I wanted to mention too, before we sign off,
Yeah.
if anybody wants a copy of these slides, I'm happy to give them out. If you want to send me an email, you can see my email on the screen, or I think they're going to be available on your website. When I just wanted to mention.
They will. Great. Linda, thank you so much. I appreciate it.
Thank you. Hey,
right.
Happy 4th of July to you and everyone else. Take
And to
care.
you.
Be safe.
Thanks, Linda.
Bye-bye.